Item 9, petitioner has already surrendered yesterday, madam. Withdrawing.
6
Hello.
Wait, please, Your Lord.
What are your instructions?
My Lord, I have discussed it with the Chief Secretary on 2 or 3 occasions. Now, so far as operating the first list is concerned, because the rule has been amended today and everybody is eligible, so we cannot make a statement against the rule. The Chief Secretary even discussed it with the Chief Minister, and it was felt.
As usual, let the court take the.
My Lord, even I discussed whether we can make everybody eligible and revise the earlier list, because the earlier list which is made
That's
was,
what we had suggested.
only,
if it is possible to accommodate all.
but then my Lord, that rule does not permit these people to apply, and there is another very substantial change in the rule. Today now,
No, in view of the amended rules, all are eligible.
everybody can apply. We will have a fresh examination. They can all compete, but that will not
That's
satisfy
not the
them.
solution.
That will not satisfy them. My Lord, I am, so therefore, to just operate the earlier list, we'll have 2 or 3 problems.
But there's another problem also. Under the old rules, these people have applied. There were certain people who were not eligible.
Correct.
They did apply and they went to the High Court.
Correct.
There must be a greater chunk of people who have not applied.
Correct. That's what the
greater chunk.
That's what the Secretary of the Department
So
said.
only because somebody has filed a petition,
correct,
in spite of the rule there being against them,
correct,
they'll get the benefit.
Correct.
A large mass will be neglected.
And there is another, my Lord, we received a spate of representations under the earlier rule. What was happening? Merit was made purely on the marks obtained in the qualifying.
Now there is a written examination.
Now, qualifying examination, every private college has different examinations and modes. So a lot of people started making representations that that's not a proper way of assessing inter-C merit. Therefore, the second major amendment which we have introduced was that now we have take a written exam and the merit will be on the basis of that written exam. That's the second main amendment which is made. And this amendment, Lord, I have now the order sheets of the case. The principal secretary of the department was called to the High Court on 3 occasions, and he was told that you have to do something to clear this mess. Last time he was called was on 22nd of January, given 6 days time to come out with something. Matter went to the cabinet, and on 25th, that is how the rule came to be made. I have now copies of the complete order sheets. So I have, in fact, yesterday night also had a long meeting where the Chief Secretary of the department and myself, we were all there. They had joined, Chief Secretary had joined online, Secretary had come to my office. So it's going to create a state, we can't make a statement against the statutory framework. It's going to create a lot of problem. So they have argued, my Lord, your Lordship, in fact, I feel we are very strong on the
problem is that High Court has not decided anything.
Then it can go back, let the High Court decide those petitions is one way. Your Lordship can make it time bound. Your Lordship may set aside this order, let it go back to the High Court to decide on merits. Or your Lordship may decide it, Lord, they have argued, let them make out their case. I'll make my reply.
Decide on merits.
Yes, I think
no point in sending back.
Correct. I agree. I bow.
Not if they want to complete their reply, because your Lordship had stopped us.
Yes.
Let them complete their reply. Or we can reply to this, then he'll want to reply to that as well. There's no point. So if there are any more points that we have to meet.
The first one you have completed, first round of argument.
We have completed our first round.
My friend completed, Lord, your Lordship said we have to ask query from them, so therefore, Lord, I held back.
That is why, my lord, Mr. Kumar did not argue.
I held back, my Lord.
So let them complete their argument now, my lord. Unless your lordship wants us to complete the argument, I don't know.
Then complete, then I'll reply. If Mr. Kumar wants to say something, let him say in whatever reasonable.
No, we'll do it in reply.
Plus
We can do
10.3 is on the same line. We
Must be on the same line.
Yeah, we
And,
cleared it right in that first
yeah.
round and we called for
If
count.
there is anything.
And then
Additional,
this AICTE thing came, which is contrary to my.
Time there were people who were deprived because of this rule to participate in the process of selection.
My lords, I
Yeah.
in certain cases, then limited to people who have approached.
No, why? Because a person who believes in rule of law, a person who believes in statutory rules didn't apply. What will happen to them?
Subsequent, that would be
No.
My lord, may I interject? Rule 9. Nothing. They on affidavit have said there is nothing wrong with the rule. The AICTE has said in affidavit that it is nothing wrong with the rule and clarified.
The rule didn't allow people
No, my lord.
getting degrees from private university.
No, my lord. No, let me just say, my lord, there is only one page where they have said there is an error. Otherwise, they have said certain error.
Mr.
They can't improve their case
you
here.
may complete your
Not-
arguments. There is no point in piecemeal hearing.
So I'll reply, my lord,
You may complete-
because written examinations were there before 2015. It was a conscious decision of the government and the commission that written examination should be discontinued in Bihar.
Already argued last time.
No, this I have not argued. This I'm merely responding now.
All throughout they had supported, only at the last minute. So
This is a fresh serial number 11, since this is likely to go on for later bail case. First, because this seems
just 5 minutes.
I'm grateful.
We'll take this.
Complete. Wait.
I thought you're also there in this case.
I was just
Machineries are used only for arm testing.
Okay.
Yes, Mr.
No, he was going to complete his argument.
Let them complete one side, my lord, because there are 2-3 people, and then I'll respond comprehensively.
Sir, you have, I think, already completed your arguments.
No, I've completed my argument.
But
Yes.
Mr. Ajit Kumar,
He is on his way here for a
okay,
moment.
any other, you are appearing?
I appear in 10.3. Now, my lords, in furtherance, just, I mean,
Sorry?
I accept whatever my learned senior has said before me. I only want to say that this particular advertisement or
In
applications
one
was issued.
minute, I'm back. Less than 1 minute.
My lords, the advertisement is of 8th of March 2019. We are the people who applied against that.
You are in 10.3.
10.3.
Yes.
Now, my lords, we participated in that.
We are
process
accepting
by
the
putting-
arguments.
Yes. We participated in the process and we were invited for counseling. And there was an objective criteria which looked at our marks that we had obtained in our qualifying courses and our work experience, etc. And based on that, we were invited for counseling. We participated in that particular counseling. And the final results were declared on 2/4/2022, in which we were shown as selected. My lords, all the document verification was carried out so far as we were concerned, and we were shown in the list as selected. And it is only after that that they changed the thing by bringing this nebulous criteria, which is not even mentioned clearly anywhere, that private colleges who were actually recognized by UGC should have had the AICTE approvals, which is contrary to the Supreme Court judgment. In the case of Bharti Dasan, which has already been cited by, it has been mentioned by Mr. Dhawan just before. Now, my lords, my submission for my lords' consideration is this. Clearly, as per the advertisement that was invited, there was no such requirement. The advertisement does not state any of these requirements. We applied, we were found suitable, we were shown in the list of selected candidates. It is subsequent to this list, which is of selected candidate, they change the idea and they suddenly come out with a nebulous criteria. My lords, I rely upon...
So then your name was later on deleted from the list.
My lords, then subsequently they took out those two other lists in which they didn't show our name.
Okay.
But in the first list...
So your case is not identical to that of...
Only to that extent. Only to that extent.
You form,
but my lords,
you form a different category altogether.
yes. But my lords, my submission for my lords' consideration is this. That in the first list, no such criteria was applied. Neither the advertisement had any such requirement. I apply apropos to an advertisement. Now, in view of the judgments of this court, in the case of C.T. Sivanandan, as well as the Salam Samarjit Singh, those are constitution bench, I have a legitimate expectation, number one. Number two, the rules of the game cannot be changed once the game has begun.
There's a recent judgment, I don't remember the citation, which says rules of the game can be changed. There's a recent judgment.
My lords, the constitution bench, my lords,
It's reserved. And they have dealt with the earlier judgments also.
my lords, but the constitution bench, which was C.T. Sivanandan, which was the district judge's appointment matter, where whether the Viva Voice marks could have been a minimum number amount percentage marks, which was not there earlier, that could be done. This court struck it down. It struck it down in the Kerala case. It has struck it down now in the Jharkhand case, which is a recent judgment of Justice Rishikesh Roy. Subsequently, in Salam Samarjit, the same issue has come up, and that is also a constitution bench judgment that takes the same view. So, my lords, today, the advertisement didn't prescribe for any of this thing. We were found to have selected. We had cleared it. We were even shown as selected candidates. My lords, for what nebulous reason? And that, as my learned colleague before me has already pointed out, it is completely nebulous until the end. And my lords, the drop-down list of colleges in that application form had our colleges in that. So it is not that we had to fill our college manually. They had a list of colleges in that advertisement, which were the approved colleges according to them, from where a particular person who has passed out, had obtained a degree, could apply. And our colleges were included in the drop-down list.
So there is no clash between you and learned senior.
No, none at all.
Because once you are inducted,
yes,
large number of people from his list will be deleted because number of vacancies.
Well, we are only 57.
Okay.
We are only 57. We are not like we have many large numbers. We are only 57.
Then it's okay.
My lords, on something that my lords had put to me shortly.
All have come here. All have come here.
Yes, my lords, 58 have come. 57 or 58. My lords, there were 99, my learned colleague tells me earlier. Only 57 or 58 are before this court now. And my lords have in the past held that people who have approached the court because they have gone ahead and exercised their right, they would be entitled to that particular protection. My lords, if people haven't chosen to approach the court from 2017 until now, or whenever the select list came out, then my lords, clearly they are not agitating their right. So, my lords, I would respectfully therefore submit that I am, with the case which is presented by my learned senior, Mr. Dhawan, but I would say I'm better. Why? Because when they were provisioned, the list was taken out, our names appeared in the very first list. And the reason to exclude us is completely nebulous, as I would say.
Okay.
But that list only not
My lords, earlier there were 93 before the High Court. Before, my lords, we are 58 of us in
You
that.
said 99.
93, my lords. My learned friend had to check up from the writ petition exactly the number. My lords, may please correct that. I'm very sorry. 93 before the High Court, 58 now before my lords in the present as well. In 10 points.
May I speak? In 10.4, my lord,
I am representing, my lord, 123 petitioners, my lord. My case, my lord, is also the same putting, my lord. We appeared in the selection process, my lord. Our my lord, name found in the merit list, my lord. It is the next, my lord, from page number 90, my lord. 91 to 144. Thereafter, my lord, what has happened in this case, my lord?
That is Sneha Bharti and.
Yes, sir. Because what has happened, my lord, the earlier rules doesn't say that if you have taken the degree from university, then it requires the approval of AICT. Thereafter, in the mid-lord in 2017, the confusion occurs because
In fact, you are also supporting the.
Yes, my lord. But my case is this, my lord, that because AICT has given a affidavit before the Honorable High Court, which my learned friend has read, that those persons who have taken the degree from university, that does not require the approval of AICT. Therefore, my lord, my submission is that, my lord, what is our fault, my lord? The fault is on the state. Lord, why we should be, my lord, they are not selected in this selection process, my lord? First of all. Second, my lord, lordship will see in the similar situation, my lord, where the state has taken decision to cancel the selection process. This Honorable Supreme Court has said that no, in this type of cases, my lord, the selection process cannot be two-page judgment, not Btsc, my lord.
And I have a copy.
Yes, yes, yes. There is technical glitch, my lord, in some of the result, my lord, and the state has decided to cancel the process, the entire process, and the High Court has approved it, my lord. Kindly see, my lord, page, next page, my lord. 126. It is the case of, my lord, Kumari and Anamika Mishra versus UP Public Service Commission. We allow the appeals, set aside the judgment of the High Court, and direct that order of the Public Service Commission cancelling the written examination stand vacated. In lieu thereof, we direct that the results of the written examination shall stand sustained and shall form the basis for the interview, part of the recruitment, and one of the basis of the two examination, and in terms of the recruitment rules, fresh selection for admitment.
How are you citing this? This is on the facts of the.
What I am submitting this, Lord. We also go by the judicial precedent of this court, Lord. In none of the single, there is not a single judicial precedent, Lord, in where this type of cases, Lord, the selection process has been cancelled, Lord. And this court has approved that, Lord.
Okay.
My learned friend, the state council, has already said that there are now 9,000 vacancies, Lord. My submission is this, Lord. The petition before this court, Lord, may be allowed to be selected, Lord, and thereafter the first admission should be selected, Lord. The vacancies are now in 1,000, Lord, and the petitions hearing, Lord, are not more than 300 or 200. I am representing 123 petitions, Lord.
Your good name, please.
Prem Prakash. There is also one application for implementation, Lord, for one petition. I am so grateful.
Yes,
Because
anybody else?
My lord, I am in 10.1, my lord. And my clients are 10.1. Sunil Kumar. My number is 528, my lord. 528 of us have filed the special leave here, my lord. Mr. Ranjit Kumar is leading me in this matter. He's on his legs, my lord. Submission before your lordships, my lord, is that midstream the rules have been changed, my lord. I was in the list till the very end. Counseling has taken place, and the rest of the arguments as put forth by Dr. Dhawan, my lord. I adopt all.
Okay. That's it. You are in.
I am in 10.2. It's at page C. I have set out. I have not only selected, I have been placed in the departments concerned, my lords.
You are not joined.
No, we are joined. We were.
You are all joined.
No. Nobody has
We've
joined.
been allotted. We've been allotted.
Nobody has joined.
That is the same as the.
Yeah.
No, so how do
If
you?
my friend is working, then he should continue working there.
I'm sorry. We were allotted as per the.
Oh, that was the case of all selected.
My lords, I adopt what has been stated, my lords, and I just want to draw your lordship's attention that in case the last paragraph of the judgment, my lord, where it is stated that from the date of the last advertisement till date, almost 4 years have elapsed. Therefore, such of those candidates who are likely to be overruled with reference to the ensuing advertisement, the state government must make provisions for them also.
Or that the judgment itself is very clear. The judgment,
The judgment says that, my lord, so at least to that extent, the protection must continue, my lord.
Okay. Yes, Mr. Pradhan.
Now, my lord, there are
Before Mr. Walia starts, my lord, I am a respondent. State petitioner before the Honorable. I'm just beginning my case, my lord, and Mr. Walia can.
You have not applied.
My lord, I had applied, my lord.
But not considered.
I was not considered, my lord. Though when the drop-down list came, my institution was there. My lord, I'm appearing, my lord, I must indicate first for 4 respondents, my lord.
1 minute. You are in which matter?
My lord, item 10, 10.1 and 10.3. I have respondent numbers 72, 73, 7
And 10.1.
and 10.3. Responding numbers, my lord, 72, 73, 74 and 77. I was one of the hit petitioners, my lord.
72, 73.
74 and 77. In item 10, my lord. I can give the other numbers, my lord. later.
इस petition से हमने ये लिया था थी क्या?
Now, my lord,
That's
I
all.
applied, my lord. And the drop down, my name of my institution was reflected. So I was able to apply, lordship. Though my institution is not affiliated or recognized by AICTE. However, my lords, my case in the writ petition was, and which was supported by AICTE, that AICTE does not grant recognition, my lord. My lord, we have seen that counter affidavit of AICTE. I may just indicate that, your lordship.
That was pointed out to
That
us.
was pointed out, your lordship. So now, my lords, I applied, but at the stage of conciliation, my candidate.
Okay, one more thing. Do we have a class of petitioners who never applied and went to the High Court?
No.
No.
I don't think.
It's okay then.
So at the stage of counseling,
I don't think
my
that
case
is-
was.
Not the class of petitions that went to the High Court impugned the rule.
No, it's okay.
Ah.
But they did apply.
They,
Yes.
yes.
They impugned the subsequent rules. The time, not the.
No, the original rule.
Original rule.
Perhaps
2017.
So you were not permitted to.
My case was not considered, my lords. So I was not in the select list, my lords, because my institution was not recognized by AICTE. Now, AICTE in its counter affidavit, your lordship says they don't recognize individual institutions, my lords. And therefore, my lords, I was left out. I derived my strength in my case, my lord, from the counter affidavit of AICTE also to indicate that all the institutions, my lord, have to just follow the guidelines of AICTE, but they're not individually recognized by it. And my lord, my only other, my lord, it has taken us so much time, my lord. If the fresh selection starts under the fresh rules, my lord, it may take a little more time. I'll be debarred by age, my lord.
No. The biggest problem under the new rules is that there is now a written exam.
Yes.
That's the biggest problem.
Everybody wants to avoid that.
Yeah, everybody wants to avoid that.
Correct,
This is what my limited understanding is.
Correct. So let me just explain.
Because madam, try to understand. Madam, try to understand. There's an institution which is very liberal in giving marks. There is an institution which is not so liberal. And based upon your marks and your mark sheet, you are being appointed to a particular post.
No,
There is no standardization in respect of marks.
there is
of different
standardization
colleges.
under the original rule of 2017. The standardization is performance based. And therefore,
Performance where?
performance in their academic performance.
That is reflected in your mark sheet.
No, my lord, if
That is reflected in your mark sheet only, sir. There's no.
No, not the mark sheet, whether you're first class or not, your mark.
This is what I'm
then
saying.
coded.
This is what I'm saying. A institution.
Yes, no doubt about that. But the point there, my lord, is that the change was made in 2015.
That we have
not to go on a written examination. And therefore, the validity was not impugned on the basis that there was something wrong with the criteria, the qualification. Now, if we go to the new rule, we would be faced with challenges which were not there before. And that is where the argument of my learned friend and legitimate expectation comes.
That is what I said. The challenge of examination will be there.
One more
The
submission.
challenge of.
If I can respond.
I'm sorry.
Yeah.
It will become overage, Lord. The overage.
Overage,
that-
Overage is taken into account. I will make a statement here. Everybody will.
I will just add
Our affidavit
one
says
thing
so.
more to what Mr. Dhawan has just addressed. Institution, my lord, put to me that there will be institutions that may give higher or lower mark. The list of institutions were approved by them because they appeared in the drop list. They didn't include everyone. They must have definitely
No, we
scrutinized.
included everyone.
1 minute. They would have scrutinized the institutions that they found suitable or candidates who had qualified from such institutions. Number one. So therefore, for them to turn around now and say that, sorry, somebody may have had something else, a yardstick, and other may have, I don't think that is open to them. My lords, number two, it was not just an educational qualification that was the criteria. There were marks allocation for experience. And for those of us who had worked previously, that experience was a valuable consideration in this selection process. So, my lords, having consciously changed from a written exam to this particular procedure, identified the institutions which appeared in the list which they found are appropriate. Number two, my lords, the subject of our experience. My lords, therefore, there was a rational, valid criteria for the purpose of selection. Today, to turn around and say that no, today you take an exam, or that because your institution was not given the certification by AICTE, you are out, when that was not the original case.
So Lord, let me.
Okay, yes.
This will never finish.
Lord, let him, because we have things to say, my lord.
Sorry?
We will do it in reply.
Okay.
But since a clarification was sought, my lord, I was sitting comfortably in the chair, my lord.
You may sit.
That is why I got up, my lord.
No. You may sit comfortably. We are not.
Thank you.
My Lord,
Sir, it's see, unless and until some query, suppose I'm having some query, some question. So unless and until I get an answer, I mean, it keeps on bothering me.
No, fair enough, my lord. I will pop up.
So there's another way also. There's another way also, just to keep quiet, listen everything and pass a note.
Of course,
that's
I appreciate it.
That's not that.
Questions to
We
us.
don't know what is happening.
Great.
So, Lord, let me just try to explain what we have done and why we have done. Now, to say that we chose institutions, that's not correct. Our rule said all
The
institutions.
question is, could you have changed the rules of game?
We have not changed the rules.
You have.
You have.
My Lord, let me
Till the final selection list was there, till they were allotted the particular departments, and thereafter you have come out with this.
So, my Lord, your lordships have made an observation of final select list. I have something to say on that.
Yes.
Let me very briefly tell your lordship what happened.
You don't deny that.
And then, no, we have denied it. Yes, I'll read. I'll read my affidavit, my Lord. I will read my affidavit.
That is 2/4/2022.
Yes, 2/4/22. I will address comprehensively on that. There are two affidavits to be read on that. What is the status of that list? Now, my Lord, what actually happened was, our advertisement said, all those who have qualified from Technical Educational Council and universities recognized by the All India Council for Technical Education. When this advertisement came out, writ petitions, not one, but various writ petitions were filed in the High Court. One writ petition is at page 90. Please see page 90. That writ
What is the date of your advertisement?
The date of our advertisement
This is in which item number, sir?
Manoj, I am arguing from Shashi Bhushan Prasad Singh versus State of Bihar.
That is first one.
That is the first item.
So what is the date of advertisement?
Yes, sir. 8th March 2019 is the date of the advertisement at page 80. The translation is not very good, Manoj, but 8th March. Writ petition is filed, Manoj, challenging that advertisement, which they have placed on the record at page 90. Please see page 90. At page 910. First, kindly see 108. What is the prayer in that writ petition? Page 108, the prayer. page 108, through the instant writ application, the petitioners, your lordship got page 100?
Yes, please.
The petitioners pray for issuance of an appropriate writ order or direction for granting following relief. For quashing Rule 9(1)(3)(I) of Rules Bihar Water Resources Department Recruitment Rules contained in notification dated 7th November 2017, prescribing technical qualification, eligibility for selection appointment to the technical post in the state of Bihar as being inconsistent with other statutory provisions, in contravention of the Honorable Supreme Court's judgment, and is violative of the fundamental rights guaranteed under the Constitution. So they clearly challenged. The second prayer is for declaring that rule ultra vires the Constitution.
That was not declared ultra vires.
For ultra vires
In the petition, in the petition.
Pardon?
They may ask anything, but
The-
what was the outcome of this petition?
Yes, yes. Now, in these batch of writ petitions,
Please wait.
on 6th, just outcome is this final order which is passed, which is impugned before your lordship. Yeah. Along with this writ petition,
This petition, pending this petition, you amended the rules.
correct. Why it came?
Apprehending that this might be allowed.
No, we amended it because the court felt that what we were doing was completely wrong.
No,
Our-
not felt from
Our
where do we get that?
I'm just passing on.
Felt?
I'm just passing on.
Bhartiya, sir.
I'm just.
Sir, please sit down. Please sit down, sir.
I am very grateful to the intervention. He says the rule is against Bharti Dasan. That's the whole point. I agree with him. He's right in that intervention, and I'm grateful for that because the rule is violating Bharti Dasan, and so therefore, my lord, when the writ petition remained pending, your lordship may note, apart from this writ petition, spate of other writ petitions were filed challenging these orders. On 6th December 2019, please note this date.
Yes, sir.
On 6th December 2019, an interim order was made in this batch of cases saying all selection shall be subject to the result of this writ petition. Now that order is on the record with my written
That's the
statement.
standard orders being passed in all the matters.
Yeah, that's all right. That's all right. Your lordship will consider the overall situation, and then, my lord, as a state, I have to bring the facts before your lordship. When this writ petition remains pending, is filed, we file affidavits saying our rule is all right. Exclusion of these candidates who have not got recognition from the AICTE, though they have passed from universities recognized by UGC and private universities, we said this exclusion is justified, our rule is right. However, AICTE filed a counter, and in the AICTE counter, the AICTE said their stand is wrong. We don't recognize any university, and those universities recognized by UGC are as good as anyone recognized by us. That AICTE counter is on the record. It was read. Your lordship may just note page 140 of the paper book at page 143. I don't need to read it again. When this pleading in the writ petition becomes complete, please pass on the copies of yours. When these pleadings in the writ petitions become complete, the matter is taken up in court. Give a copy to them also. The matter is heard on various occasions from time to time. Please see, these are the complete order sheets of this case where this judgment has come, which I am passing on to your lordships. Please read page 16. Please read page 16. These are complete order sheets. Page 16.
The order sheets of which matter?
This very case, of which the final judgment your lordship is hearing a challenge to.
No, that was 1 minute.
Is this very case?
So the very case is in 3411.
This is in 3411.
Common order.
The first page 14, my lord, is the title of the first writ is 3411. It is the complete order sheets of these very cases. Now kindly see, the AICTE at page 16 files a reply. Learned counsel is hereby directed to furnish copy of the counter affidavit. The proceedings continue, my lord. One other order is at page 30. After hearing at length, the court makes this order on 13 December 2022. Page 30. Heard the matter at length. Learned counsel for the state is directed to get positive instructions by means of affidavit of the first respondent as to whether before issuing rules called the Water Resources Department Subordinate Engineering Service Cadre Amendment Rules 2017, which they are relying on. Their case is based on this rule. A draft rule is required to be notified, inviting objections, suggestions from such of those persons whose rights are likely to be affected. Whether such draft rules were notified or not, affidavit shall be filed. Affidavit probably was not filed, but we told the court that no such draft rule was. Affidavit was filed. All right. Affidavit was filed. It was stated no such draft rule was notified. Then please see the order at page 36. The principal secretary of the department is directed to appear in court and satisfy the court. Page 36. Principal Secretary, Department of Water Resources, Government of Bihar, is directed to comply with the order of 13 December and also come present in court on the next date of hearing. Relist on 17th January. This is an order of 10th January. Only 7 days time was given. Next matter was again listed after a week. Then, my lord, on page 39, your lordship may see the 17th January. 9. Today, Sanjay Agarwal, Principal Secretary, is present in court due to administrative difficulties in the department as well as in the Office of Advocate General. Counsel for the state seeks time. List on 24th. So again, after 1 week, it is listed on 24th. Then, my lord, on 24th, the matter is heard. Page 42. Lord, I am answerable to 3 people. 2 plus 1. So,
First there and then.
That was said in such a hushed whisper. I don't know what he said.
You have again popping up.
But I can see your lordships there because you're on the screen.
So, but see, we can't see you. That's the problem.
There is a screen this side as well, my lord.
It should be there. Right there.
Now your lordship. Now those cameras are switched on.
But
So, Lord, on 24th, immediately after 1 week, the matter is called. On 24th at page 42 is the order. Learned Advocate General on instruction submits. There were elaborate discussions at the administrative level in the state of Bihar insofar as complying of order dated 13 December 22. They still require 2 more weeks because there was no draft. So the court said this possibly cannot survive. Therefore, relist the matter on 2nd February. Personal appearance of Sanjay Agarwal, Secretary, who is present in court, his presence on the next date stands dispensed with till further orders. On the very next day, 25th, then, this meeting is called where a decision is taken that we will withdraw this 2017 rule and come out with fresh rules. And that is the circumstance under which this rule was withdrawn and fresh rules came into force. And there immediately thereafter, my lord, on the matter comes up on 14th. Please see the affidavit at page 48, the order at page 48 on 14th. 2 days time is given to us on 14th because on 14th, when we say we have done this, the court says affidavit filed by the state today is bereft of material information as is evident from para 6 onwards. It is very vaguely drafted. It is very vague drafted. One cannot draw influence what is in the mind of the state. It is rejected. State is directed to furnish fresh affidavit on the next date of hearing, and the date is after 2 weeks. So, 2 days. So thereafter, after 2 days, we then file the affidavit, or we file it the very next day. The matter comes up the day after that, and that is how the matter gets decided, saying that all right, these rules have been withdrawn. Now the requisition should be withdrawn, and you please take the fresh advertisement.
Just give us the dates when this decision was taken.
25th, 24th, the secretary appears. Page 40.
No. At the government level.
25th. 25th January. 24th January is the hearing when the court, if your lordship will see, my lord, from 7th of January up to the court, in fact, the whole thing starts on 13th December at page 30. when the matter is heard at length on 13th.
1 minute. Decision was taken at secretariat level.
This is approved by the cabinet, right?
When?
The decision is taken at the chief secretary level, and the rules are framed after approval of the cabinet. So therefore,
I want the dates.
dates 25th is the decision.
25th the resolution.
Malad,
Page 339 also this will be.
The decision was taken by the chief secretary on 25th January 2023.
Correct.
Thereafter, it must have gone to cabinet.
I don't have the date just now. I'll just get it and give it. Just find out on paper.
Never said, never said.
Cabinet.
Never said that went to the cabinet. It was just said that it was a pass.
That's what.
If my friend can stop this, Malad, I am not going to conceal anything. If it has not gone, I will say it has not gone. I have no intention to conceal anything from this court. I am trying to just assist the court as a state counsel. If they get appointed, best of luck to them, Lord. I have no intention to conceal anything from
Yes.
anyone. But in the meeting yesterday with the chief secretary, I was told
By the government.
yes, by the state.
There's a cabinet.
Correct. Para 10 of my affidavit here before your lordship.
Also, we want to know when did it go to cabinet? When did it go to governor? When they were published in the gazette?
That date of publication, 7th March, Malad, we have said so. If just come to my counter here, I have explained everything. Please come to my counter here, and I am just going to read my counter because that counter says everything.
One to four.
Yes, counter of 1 to 4. And I'm just going to take your lordships quickly through this counter because every fact has been stated here.
Which page?
The first 3 paragraphs are formal, Malad, where we say who is filing it. Para 3, we have reproduced the order which is under challenge. Please see it from para 4 onwards. We have explained why we did what we did.
No, that's right. That you have already shown. Now
All right.
tell us.
I can leave that, Malad.
Yes.
I can leave that.
When did you take the decision at secretary, chief secretary?
Yes.
When did you?
At para, kindly have page 8 of the counter.
Yes.
So far as forming of the rules is concerned, the new rules. Para 8 at page 8.
Yes.
It is pertinent to mention that a meeting of the principal secretary of all the works department, along with additional legal remembrancer Bihar, was held on 10 July 14, 7th August 14, under the chairmanship of the Chief Secretary Bihar, with regard to framing of the aforesaid rules. In the said meeting, recommendations were made with respect to eligibility criteria and mode of selection in subordinate engineering services. In the light of the said recommendation, the aforesaid eligibility criteria with respect to qualifications were incorporated in the draft of the rules. That before notifying the rules, opinion of the Science and Technology Department Bihar has been sought for on draft of the rule-wide letter dated 31st July 14. The said department said
2015 and 17.
send its opinion on 25th August 14 that the AICTE.
Well, I'm sorry to interrupt so that there is clarity. all that is being read is prior to the rules that were impugned. The rules that are...
Correct. I'm reading it. I'm saying what happened earlier.
Now this happened. We are not doubting that the rules went to the governor and that the governor... just one second.
When? Because...
No, my lord.
Because
the 2017 rules...
That second part...
The High Court said that they are permitted to amend the rules.
That's
no permission.
No.
So that is at page. My lord, if they allow,
may I just
they
say
cannot
that
interject like this.
This is just 1 second so that we are clear.
We are very...
This process that my learned friend is reading does not pertain to the later supposed rules.
So I am reading the entire situation. Why we...
Mr. Patwale, just come to the point.
All right, then come to page 18. But before that, I have to read some...
No, that was pertaining to the earlier rules.
Yes, then come to page 18.
Yes.
Page 18, para 23.
Also, I will...
Lord, they can't go on like this, Lord. I have to be heard also. Either let them be heard and case be decided. That's what they want, I think.
No, we all want the case to be decided, don't you?
So, my Lord, just see page 18.
Said that the rules of 2024 were placed before the cabinet, approved by the cabinet,
and gone to the governor and published in the official gazette.
I can see whether it is, what I have said is page 18, paragraph.
That is not done. The amended rules have never come into force.
There is cabinet approval. Print it. Its cabinet approval is 6th of March. We have the copy of the cabinet approval. But I will just see, my lord, whether we have said it before the High Court.
Never said.
1 minute, please don't interfere. Let him clarify.
Page 18.
Yes, it has gone to the cabinet. I am making a statement. If it's not there, I am making a statement of fact.
That is also not sufficient. When 309 rules are being amended, it has to go to the governor and also it has to be published in the official gazette. Then
Yes, all that is done.
When?
I can file that affidavit and give the dates.
Mr. Patwalia,
Or I can just get the dates. In the meantime, let me make my case, my lord. Let me argue the case. Because if
you can't argue the case unless this is clear.
all right, then I'll get the dates. I'll give your lordships the date.
May I just bring one thing to my note?
But like this, there are 5.
My friend doesn't.
Everybody wants one thing.
Apropos, what is the query? Lord, may I just inform? Just my friend would not mind that much. Lord, the judgment of the High Court in this case is of the decision was taken by the Chief Secretary that there are errors in the rule and we need to do something about it. That decision was dated 25/1/2023. Right. The order of the High Court disposing of the matter is of February 2023. It is thereafter, my lord, on 13/3/2023, they asked for, on 7th March 2023, they framed the new rules.
Correct.
After the High Court judgment.
Correct.
It has not happened, my lord, before.
Frame new rules by whom?
The rules are...
At what level?
No, there are new rules, my lord. It is not an amendment of the rules. It is a new rule at page 242 of my paper.
We want to know whether the procedure was followed.
Absolutely followed, not completely followed. My friend will, apart from
it says it is gazetted and it is made under Article 309. It says so, my lord. I can't deny that fact. But that came on the 7th of March 2023. Thereafter, the minutes were made on 13/3/2023 for requisitioning of the vacancies then existing, and thereafter they asked that the department.
Just kindly see page.
My friend doesn't mind.
No, my friend is interjecting. When his turn was there, he was not here.
You didn't have these facts.
No, it's there. If they allow me to say something only, then there are 5 people. Every time I make 3 sentences, every time I say something and try to.
No, you said.
They jump up and saying I am. No, just kindly see page 83. When his turn was there, he was not here. Page 83, my lord, kindly see.
That doesn't matter if I was not here.
Kindly see page 83. The new
83 of
my affidavit. My affidavit of 124. And I'll give the dates. I am instructed to state complete procedure has been followed this time around. 7th March 23 is the rule. In the exercise of powers conferred under proviso to Rule 309 of the Constitution, the governor of Bihar makes the following rules to regularize recruitment and so and so. These are the rules. They have been framed, approved by
When they have come into force
they have come into force on 7th March 23.
with immediate effect.
Correct. From 7th March 23.
So this would apply to prospectively.
On that,
How could you make this applicable retrospectively?
on that, the law is that if we take a conscious decision not to fill up the existing vacancies because we are proposing to amend the rules,